which have rattled the corporate sector in the past. For the first time, the term fraud has been defined. Stringent penalties have been provided for persons found guilty of fraud. In cases where deposits are accepted with intent to defraud the depositors or for any fraudulent purpose, the officers concerned will be held personally responsible, and I think this is very necessary. One of the most discussed provisions of the new Act is the class action mechanism set out under the new Act. Class action procedures form an integral part of the jurisprudence of Western countries. Despite the popularity of such actions in countries such as United States of America, such shareholder actions are rarely undertaken in India. Though the Civil Procedure Code since 1908 provides for representative actions, the inclusion of a specific class action mechanism under the new law is indeed a welcome development. Class action is covered under the heading Prevention of Operation and Mismanagement and gives right to a prescribed number of members or depositors to file a class action, inter alia to restrain a company from committing an act which is ultra vires the charter documents, to restrain the company from doing an act which is contrary to law, and to claim damages or compensation from the company, its directors and auditors for fraudulent, unlawful or wrongful act or conduct. Sitting as a judge of the Gujarat High Court, I had an occasion to deal with a case sometime in 2004. The fluctuating rate notes were issued by a company and there were defaults. One of the note holders, having substantial number of notes, filed a winding up petition in the High Court. And the defense raised by the company was that, sir, only the trustees can give a discharge. So this individual note holder has no right to file a winding up petition. They relied on a judgment of a British court which was rendered in 1879 and which was still considered to be a leading judgment. The Chancery Court in Uruguay Central and Higueritas Railway Company of Montevideo in the year 1879 had held that a debenture holder did not have an immediate right of action for money lent or money due because the company is liable to pay the trustees under the deed, and therefore the company cannot be sued twice over. They said if an individual creditor is allowed to sue the company, and thereafter if the trustees also sue, there will be double action. So this is what they held. Allowing the debenture holder to sue the company would require the company to face two actions, one by the trustees and the other by the holder of the coupon. It does not appear that it was the intention of the parties, which is after all the governing rule in deciding the questions. Hence, the holder of a coupon, note or debenture is not a creditor either at law or in equity within the meaning of the Companies Act. This judgment given in 1879 was holding the field, and I had to deal with the preliminary objection of the company that in view of this judgment, the debenture holder, the note holder had no right. So what was to be done? I could not have overruled the principle which had held the field for the last more than 125 years. I found out a way. I said the debenture holder, the note holder, should be allowed to file the winding up petition if he joins the trustees as a party. So once the trustees are also before the court, there is no difficulty of having two actions. In the same action, the rights of all the parties can be decided. I also found out that the judgment which was considered as the locus classicus on this principle began with the words that in this case we did not receive proper assistance from the lawyers. So that judgment was holding the field for 125 years, and therefore I found out this solution. So it is hoped that with this new act providing for class action, it will be now easier for the debenture holders and such other creditors, shareholders also, to sue the company for all the necessary remedies. Keeping in mind the principles of transparency and accountability, the Act makes provisions for rotation of auditors who are bestowed with the duty to protect the interests of investors in a company. Auditors would be held liable if they knowingly or recklessly omit certain information from their reports thus strengthening the system of checks and balances. The role and position of independent directors has always been a subject matter of debate and discussion. The issue is immensely important since independent directors safeguard the interests of the shareholders of a company. The term independent director has been clearly defined in the Act, which now throws light on various aspects like the minimum number, tenure, remuneration, etc. of the independent directors and attempts to bring in clarity on this subject. The Act spells out specifically the duties expected of directors of a company. I am also happy to note that the Parliament has now provided for appointment of professional liquidators so that the liquidation proceedings in relation to small companies can be expedited. Earlier, the experience was that if a winding up petition is filed, it is admitted, and even if it is allowed within a year or two, the actual winding up proceedings would never come to an end. And therefore, as a lawyer, I would always tell my lawyers who are exclusively practicing on the company side that you are very lucky fellows. So you would ask why. A close friend of mine was practicing exclusively on the company side. And I told him that you are very lucky. So he said, why? I said, you are like a doctor, you know, the dermatologist, the skin specialist. The skin specialists have three advantages. There is no emergency. So that is also the advantage which the company lawyers have. Nobody wakes them up in the middle of the night to get an injunction. Second emergency is that, second advantage of a skin specialist that the patient never dies because of the skin disease. So the company matters also never are closed. And the third advantage is that the patient is never cured. Super. So this appointment of professional liquidator, I think, will now take away these advantages which the company lawyers were hitherto enjoying. The Act also provides for constitution of the National Company Law Tribunal and an appellate tribunal known as the National Company Law Appellate Tribunal. A specialized adjudicatory mechanism has been contemplated with both judicial members and technical experts having experience in the corporate field presiding over specific disputes. I hope that there is also a special tribunal to deal with the economic offenses under the Companies Act, because with what has happened in the United States, that a person found guilty of insider trading could be convicted within a year of the crime having been committed. I think people are now expecting the same speed and efficiency with which the system is working in other countries. This will foster specialization, provide for a time-sensitive dispute resolution mechanism, and reduce burden on the regular courts. I have already informed you about the statistics of the pendency of cases that we have. The government has been empowered to constitute special courts to ensure speedy trials and disposal of cases. A special court shall consist of a single judge who shall be appointed by the central government with the concurrence of the Chief Justice of the Jurisdictional High Court. A specialized agency for investigation of company-related frauds, like serious fraud investigation officer, have also been provided for under the Act. The New Companies Act is thus the result of detailed consultative process adopted by the government. It is therefore a move in the right direction. It is a structure which has evolved out of the experience gained over a number of decades and which now provides for an effective regulatory mechanism. It is an experiment embodied with a forward-looking approach and aimed towards progressive development of the Indian economy. However, the impact of the new legislation on the functioning of the businesses will be clear after the rules and regulations are framed under this enactment. The Companies Act 2013 is thus going to change the way companies are incorporated, they raise money and interact with stakeholders, govern themselves and contribute to the nation building. The very fact that the history of the business world changed upon adoption of this concept of formation of a company with limited liability. It is since then that the business structure, business world has completely changed. So I'm sure that with this new change, with this new legislation in the Indian legal and regulatory landscape, this will be the first step, which I hope also becomes the giant leap for corporate law jurisprudence. I'm very happy that the organizers have selected very important topics for discussions at various technical sessions of the conference today. I'm also conscious of the fact that those who are not good enough to speak in the technical sessions are usually invited to inaugurate the conference. So I'm happy to inaugurate the conference, and thank you for inviting me.